Throughout the ages, human societies have had rules regarding behavior, along with rules regarding the consequences of behavior. Human beings, natural persons in the legal terminology, are generally considered responsible for their behavior as manifested in their actions. There may be exceptions based upon age, mental capacity, or state of mind at the time of the action. But as a general principle, adult members of society are expected to follow the rules. There is another category of persons besides human beings, known as legal persons. For this category as well, there are rules to be followed. But for certain legal persons, the general rule of responsibility for their behavior is not full responsibility. Instead, such legal persons are often relieved of the responsibility for the consequences of their actions. This is the concept of limited liability. It is a fundamental principle of most legal systems which recognize the institution of the legal person. Legal persons have been around for ages. Okay, maybe not in the Stone Age, but evidence of their existence goes back at least a couple thousand years. The idea of the legal person was known in Antiquity. Ancient Greece built upon the collective in forming one of Europe's first city-states. But it is to Rome we must go to dig deeper into the details of the legal person. Roman law recognized a number of forms of legal persons, each with its own characteristics and reason for being. The municipes, or municipium, marked the amalgamation of citizens in a particular area. It is from this term that we get the English word municipality. The res publica took this concept to the next level and marked the entire Roman Republic. It is from this term that we get the English word republic. Religious bodies also constituted legal persons as collegia, such as the institution of the Vestal Virgins. It is from this term that we get the English word college. Collegia, or collegium in the singular, were capable of receiving and owning property in their own name and on behalf of the collective. Certain professions also organized themselves on a collective basis in order to confirm and preserve rights, as well as to organize their activities. One example was the scribae, or scribes, who performed the crucial role of recording information in an age before the printing press and computer. Last, but arguably of greatest relevance to the topic of limited liability, there were legal persons devoted to the activities of trade and commerce. Though these examples of legal persons differed somewhat in their purpose and operation, they shared certain essential characteristics. 1. Their existence could be decoupled from the lives of the individuals operating through them at any given time. 2. They enjoyed legal privileges in their own right, including the right to own property. Both of these abilities, or traits, stemmed from the idea of the legal person having its own identity or personality. Legal persons were, and are, of course, artificial persons which depend upon human beings to carry out actions in their name and on their behalf. They are an example of a legal fiction, a theoretical construct created by a legal system to achieve some specific purpose. This is a basic but important point. For just as the writer of fiction is free to determine the nature and direction of a fictional character, a legal system is free to determine how legal persons come to exist and what rights and obligations accompany this existence. We will explore the nature of those obligations throughout this episode, focusing on the specific issue of liability, the legal term for responsibility for the consequences of one's actions. In ancient Rome, the legal position on responsibility of collectives was summed up in the following maxim: Si quid universitati debetur singulis non debetur, nec quod debet universitas singuli debent. Roughly translated, that which the group owes, an individual in the group does not owe, nor does the group owe that which the individual owes. Those 5 years of high school Latin have really paid off. This short phrase sums up a key driver for the creation of legal persons: the desire to separate individual from collective privileges and obligations. It makes clear that individuals, even members of a collective body, could not claim all or part of property which belonged to the collective. The corollary to that was that the collective could not claim that which belonged to an individual, even if that individual was a member of the collective. This basic proposition is at the heart of the issue of the liability of legal persons. As we shall see, the proposition has evolved to keep up with changing contexts over the centuries. Before leaving Rome, it is worth emphasizing a key variable related to the responsibility, or liability, of legal persons for the consequences of their activities, namely, their underlying purpose. Most of the legal persons accepted under Roman law had a purpose connected to some common benefit for society, or at least part of society. Many institutions, as legal persons, had their mission in improving the physical, spiritual, or intellectual life of the members of Roman society. Others were more focused on commercial activities, ostensibly to maintain quality standards and to coordinate markets. The fact that such purposes were long-term, even eternal, aided their promoters in seeking formal recognition of the collective's status as a legal person. The significance of the Roman law examples of legal persons lies in the fact that Roman law served as the basis for the civil law legal system which prevails in much of the world. It also influenced the development of the common law legal system, which covers most of the rest. In the ensuing chapters, we will trace the underlying concepts of legal persons and liability throughout the ages, and we will see how the topic of purpose resurfaces again and again in different settings.